Good afternoon. Your Honor, today I will present to you the compelling reasons that the court should allow the jury to hear the testimony and see the collected evidence at 614 Mays Street. On the afternoon of June 17, 2020, our fire department responded to 614 Mays Street in our city. On arrival, the first arriving engine company found a working fire in this residence. There is evidence of a working structure fire at this residence in the picture that I am showing you now. As you can see, there is smoke and fire showing. This picture was taken by our Department Public Information Officer shortly after the arrival of the first due engine company on the scene. Once the fire had been extinguished, crews found that the fire had been heavily involved in and around the living room area, especially near the television set. Shortly after the fire was extinguished, the fire department crews began picking up their equipment and waiting for the fire investigator to arrive. However, at this same time, the fire department received another reported fire with potentially 3 children trapped inside the structure. This reported fire was only 3 blocks away from their current location. At this point, the lieutenant made the critical decision that his apparatus needed to leave the scene and respond to this fire. This left no fire department resources on the scene to secure this scene. The defendant's attorney contends that because the fire department left the scene prior to the arrival of the investigator, any evidence seized was a violation of the defendant's Fourth Amendment rights. The Fourth Amendment is designed to protect a persons from unreasonable intrusion by the government. The Fourth Amendment does not provide protection from all searches and seizures, but only those done by the government and deemed unreasonable under the law. I will prove to you that in the case of the 614 Mays fire, that there was no violation of the rights of the homeowner and that the seizure of the evidence was reasonable and legal. In 1978, in the case of Michigan v. Tyler, the United States Supreme Court ruled in this case of a fire that the fire department does not need a warrant to enter the structure due to exigent circumstances. In this case, the fire at 614 Mays. Furthermore, the fire department has other duties such as the need to determine the cause of the fire. The United States Supreme Court also ruled in Tyler that all fire department activities such as overhaul, smoke removal, and investigations that take place after a fire are legal as long as it is done in a reasonable amount of time. I would submit to you that there are exigent circumstances at this fire scene. Number 1, the fire crew had in fact extinguished a fire at this location and was called away for another serious fire incident. Number 2, the fire investigators arrived on the scene soon after the departure of the fire apparatus, and there was a need to investigate the cause of the fire. There was evidence gathered, such as this picture of a pour pattern discovered near the television in the living room that extended towards the kitchen. This evidence makes it clear that this was potentially a set fire and an accelerant was used to set this fire. There is another case law that exemplifies the need for an investigator to re-enter private property to investigate fire without the need of a warrant. I would point to you United States v. Veltman in 1981. In this case, a warrantless search was approved when investigators re-entered several times after the smoke had been cleared from the structure. To summarize, there is precedent set forth in case law that although the Fourth Amendment protects persons against unreasonable search and seizure, in this case the evidence that was located at 614 was found due to exigent circumstances, and it was found in a reasonable amount of time. This allowed for the fire investigator to enter the premises and collect the evidence. The defendant's desire to suppress this evidence should be denied and allow the jury to view it. Thank you.